What about procedure? Well, you start with a notice of adjudication. This is a document setting out the nature of the dispute and the remedy sought. It has to be validly served on the responding party, and the provisions for that are normally set out within your specific contract. There must be an appointment of an adjudicator. That should be done within 7 days of service of the notice. It is something that can be agreed between the parties, or alternatively, you can use a nominating body, which will normally be set out again in your contract. But picking a suitable nominating body should be an important consideration when you're negotiating the contract. You then must serve a referral notice. This should be served by the referring party within 7 days of the notice. Note that these are very short timescales, and it's something to be aware of within adjudication, especially when you compare it with normal litigation. The referral notice is far more detailed than the notice of adjudication. This is essentially a full-on statement of case. It should set out all the key facts and pieces of evidence in detail, and it's frequently accompanied by witness statements and even expert reports. The responding party then responds, and this is their response. This is essentially a defence to the case, or perhaps only specific aspects to it, put forward by the referring party. And the general position is that the responding party has 7 days to serve this, but this is a timescale frequently extended by an adjudicator, or it might be extended through agreement between the parties. There can be further submissions, but this is at the discretion of the adjudicator, and they may allow the parties to serve a rejoinder and surrejoinder, or of course the parties could agree between themselves and then ask the adjudicator to set that out in their timetable.